Wish a very happy
Good morning, ma'am. Good morning.
and festival will come to an end. Nevertheless, we are still into the festivity. Uh, so yes, we have to continue our discussion on. We're still on commercial laws. We have to finish one more of special contract. Then we will speak about the Sale of Goods Act, and then we will see how we take it forward. uh, we had stopped at we had not completed agency. We had stopped at termination of agency. Can just give me a thumbs up if y'all can hear me, because there's somebody who's saying he cannot hear me. So
No, madam, the sound is loud and clear. Even the video quality is also good.
thank you so much. Thank you so much. Okay. Yes. So we had stopped at a point where I think we had to discuss termination of agency. The rest of the things in agency also we had covered. So we will, without wasting any time, move on because we really need to be a little more faster now. Just one request to everybody who has any queries, doubts. If you can just put your queries in the chat box, or at least raise your hand rather than unmuting yourselves and talking in between, because that sometimes it becomes it breaks my link too. And uh, it's we really do not have a lot of time spending on small things. So whatever those issues are, maybe you can write to me later and I can address your queries later. Like some of them did write to me last time. Some of the queries I addressed immediately, but some of them it took me a little while, but I made sure that I answered them before this class so that you're aware of what is happening. So just that one small request I would have. And with that, I will try to share my screen.
Madam, your mic is on mute.
Sorry, yes, I know my mic is on mute. I put it on mute on purpose, because when I am looking for my files, I'm sort of self-talking. I didn't want the entire class to listen to what I'm saying to myself. Sorry about that. Okay.
Okay.
So termination of agency is where we had stopped. We're not done termination of agency, and so we'll take it from there. So I'm not going to repeat the entire thing about what is termination and all. We had a good discussion, keeping in mind your shipping. The shipping context, and we had spoken about agency. So we will quickly only go through how is it that the agency can be terminated, or which termination means how an agency comes to an end. So it comes to an end by two things. It's by an act of the parties or by operation of law. So we will see how what it is basically, what is an act of the party and what is operation of law. So act of the party, when we say, it is when the parties to the contract of agency, when they do a certain thing, when they decide, when they plan to do a certain thing, it could be either mutually or it could be individually they take certain decisions. That is by the act of party very, very clearly stated over here. I don't think it needs any explanation. So mutually, when the principal and the agent decides that no, we don't want to go ahead with this agency. Enough, we have worked together enough. We don't want to go ahead with this business or with this sort of connection of us. So that is where your agreement to agency will be terminated. It could be that the principal feels that now he doesn't need this agent, so he will inform the agent. And of course, there would be certain terms and conditions which are mentioned in the contract of agency as to how agency can be revoked. What are the ways in case if the principal is revoking the agency before time, what are some of the conditions that he will have to fulfill. All that would be there in the contract, and it would depend on the contract. But yes, the principal has the right to terminate or revoke the agency by if he's not wanting to take forward the agency. And the agent can also say that no, I don't want to really work with you. I don't want to act as an agent to you. So when he's terminating or when he's canceling the agency from his side, it is referred to as renunciation of agency. So these are the three ways how by act of a party the agency is terminated. Very, very clear. Violation of law, agency be cancelled or terminated. Sometimes an agency is formed only for a particular business. There is an agency between the principal and the agent, and if that business is done, principal or the agent, not that their legal heirs will take over or something like that. So the agency is completely if in case if the death of one of the directors or one of the partners, it will still remain. But if it is individual, there's an individual principal and yes, agency will be them dies. If or becoming of an fact, if the on expiry of a fixed period, 1 year, 2 years, 3 years, if that period is over, then the agency is terminated. Destruction of the subject matter. If the agency was done for a particular subject matter, for some goods, like to take a very simple, very, very simple example, agency, there was an agent and his goods, maybe what are the goods that you can place? Maybe some, furniture. If the furniture for a particular set of furniture, but if that furniture has got destroyed by fire or something like that, then there is nothing, no subject matter for that, agency that has remained. So on destruction of that subject matter, also the agency can get terminated. Like we spoke about the death of principal or agent. If the principal or agent is a company, and if the company is dissolved, then uh, the agency will be terminated. And if the principal has become an alien enemy, so if the principal is of a different country, and the agent is of a different country, and now there is a war that has happened between the two countries. When there's a war between two countries, they become alien enemies, and then in that kind of a situation, the agent will be a company which is in the foreign country, which is in war with this country. So on these basis, the agency is terminated. Nothing very great or one be able to understand this. I would quickly like to close the chapter ahead. Very important specific type of contract to the shipping industry. That is bailment. Before we move on, or before we start speaking about the how it is relevant to the shipping industry, First of all, let me with a couple of very simple examples and very sort of relevant examples. I will explain to you what is bailment, and then we will start speaking about, in particularly, how it is applicable to the shipping industry. When I give you the example itself, and when you start thinking about the shipping business, you will understand what I'm trying to say. Okay, so uh, before even speaking about a definition or reading the definition, I will straight go on to the examples, which is very clear. And it happens to most of us in our life. We have transition in our lifetimes. Some of us are dealing with it continuously. Some of us must have dealt sometimes. Okay, so the first example is that you have a piece of cloth. Okay, there's a piece of cloth, and you want to make, it could be a shirt, a kurta, or anything out of it. Uh, who do you approach? You will approach a tailor, right, to get that thing done, stitched. Okay, so how does the transaction happen? You will take the piece of cloth to the tailor, okay, and you will tell the tailor that you want this to be, made into a shirt or a kurta, or whatever you want to do of that cloth. Okay, so you have told him the purpose why you have got the cloth to him, and the tailor will take the cloth from you. He will do the necessary things like taking measurements and all that. He may ask you, what is the pattern that you want, and all that happens. You all agree to that. He will also tell you that, yes, I will charge you so much for my services of stitching this thing. Okay, and you will give that piece of cloth to the tailor. And when the dress is done, either the shirt or the kurta, or whatever, you have told the tailor to do, specifically whatever you have told the tailor to do. Once the tailor has done that, then what happens is you will pay him for the services and take back that dress from the tailor. Correct? That is one example. Second example is, similarly, you have certain clothes which you want to be washed or you want to be ironed. So you will go approach a laundryman. You will tell him that, I want these clothes to be washed or ironed. So you will give your clothes to him for washing or ironing for some specific purpose. Okay, there has to be a specific purpose for what you're giving, not just that, you don't want the clothes and you're giving it away, but you want it for that specific purpose to be washed or ironed. And the laundryman also tells you that I take so much of rupees for these services. And you both of you all agree. You give the clothes to the laundryman. The laundryman washes or irons the clothes and gives back to you, and you give him the money. Okay, now what happens if the laundryman sort of burns your clothes, or if the cleaning is not done properly, or if the clothes have run away, or if there are stains that you observe after washing and all that? That all we will see later. The first transaction of you giving your clothes to the tailor, the tailor stitching a piece of cloth to the tailor, a tailor stitching your clothes and giving back to you, you paying him, or you giving your clothes to the laundryman washing, cleaning, ironing your clothes and giving it back to you, you paying him. This basically is an agreement of bailment. This is what bailment is. Let us have a look at the definition first, and then we will move ahead. A bailment is the delivery of goods by one person to another. You are delivering goods to the tailor. So, delivery of goods from one person to another for some purpose. You're delivering the cloth so that it is made into a kurta. You're delivering your clothes to the laundryman so that it is washed and sent back to you. Okay, so there is some purpose. Upon a contract, that they shall, when the purpose is accomplished, be returned or otherwise disposed of. That we will see later what is about disposing it of. According to the directions of the person delivering them. Okay, so there could be a possibility that I am a fashion designer, and I have given some clothes, a piece of cloth to the tailor, and I have told him that you can make this into this design, and then give it away to somebody, probably who was somebody specific, or give it away, or sell it, and give me some commission. That is disposing of. Okay, but when we speak about delivery of goods for some purpose, and once that purpose is accomplished, that is what bailment is. The person of you, and the tailor, that is the person who's taking the goods or to whom the delivery is made, is called this is the tailor and the belly. Oh, let us have a look at this from the shipping parlance. Okay, I will write something here, but you, as shipping experts, may choose to tell me that no, ma'am, in this transaction, this is also something that happens, or this does not happen. Okay, so we will take an example of a shipper. The shipper will deliver goods to the CHA, yeah, or maybe I will also freight forwarding agent. Okay, they will hand over the goods to the ship owner, charterer, basically the port. Okay, the port, then what happens? It is the goods are loaded in the ship, the ship sails, it goes to the port where the shipper wants the goods to be delivered. Okay, so again port, then again there would be clearing agents over there, right? What do you call them, or whatever names they are called by in your parlance? And then is this how the transaction happens? Any answers in the chat I can see? Yes. Okay, so this is how it happens, right? In the shipping also. So see, the shipper is transferring the goods to somebody. Okay, who, the shipper is not really bothered about the rest of the things. He's only bothered about whom I mean, of course, certainly when I'm saying he's not bothered, I'm not saying that he's not concerned about by which vessel it is going and how it is going and all that. All that he is definitely concerned, but he is trusting the CHA or the freight forwarding do the consignment to be shipped and sent to the consignee. Okay, so here the shipper is giving the goods to this agents. The agents are supposed to be giving the goods to the loading the goods in the ship. Then the ships, once the ship has sailed, it will go to the port. So the goods are removed, unloaded from the ship, and they are given in the custody of the port officials. Now again over there, it is either the they will come and they will take the goods. So when we are looking at this transaction, there are several times that the goods have been transferred or delivered to somebody with a purpose. Okay, the shipper is not delivering the goods to the agent for him to keep it, or for him to buy it from the shipper and become an owner of it. It is not that. He's transferring, the shipper is transferring the goods so that the goods are finally delivered to the consigned. Correct? So here the ship, the agent or the port officials are not going to deliver the goods back to the shipper, but they are going to deliver it to somebody whom the shipper has asked them to deliver. Correct? So they are acting on behalf of the shipper and delivering the goods to the consignee. So now again over here, the shipper is delivering the goods. So the shipper becomes a beller, and he's delivering the goods to the agent, so that agent will become the belly. Now again, the agent is delivering the goods to the ship, to the port authorities to load, or to load it into the ship. So again, he becomes a beller in that transaction, and the ship owner or the charterer or the port authorities whom he's delivering the goods to becomes the belly. Okay, again, it is removed from the ship, unloaded from the ship, and gone in the custody of the port authorities to finally give it to the shipper. Again, the port authorities over here will become the belly, but for the consigner, yeah, the ships have the goods have gone to the port authority. So the port authority, goods finally deliver the goods consignee. So the port authority is acting on behalf of all of this, or acting also on behalf of the shipper to give the goods to the consignee. So they will become the beller, and the consignee is the belly to whom the goods will be finally given. Or, sorry, it's not like that. The consignee over here is again the beller, because he is the person whom the shipper or the beller had actually asked the goods to be delivered. So he's taking the goods on behalf of the shipper. So he again stands in the hands, in the shoes of the belly in the end. Sorry, in the shoes of the beller, who's the shipper in the beginning, and the port authorities will be the belly to whom the goods have been given, but now they have to deliver it back to the beller. Okay, so this is how bailment actually comes into picture in the shipping context, where it starts from the shipper and it goes to the consignee. Consignee is also actually a party of to or a part of the shipper, because the consignee is also someone to whom the goods have been delivered. The goods that have been sent by the shippers are being delivered to the consignee, not returned back to the shipper, but delivered to the consignee, who actually, in this entire contract, if you look at it, becomes or stands as an agent of the shipper to collect the goods. Okay, so both the shipper and the consignee will play the role of the beller, and then there will be all these bellies who are having the custody of the goods for a particular period of time, and they have to deliver the goods to the bellers. That is, the shipper is not taking the goods back. Who's taking the goods back that have been sent by the shipper is the consignee. Okay, so in this whole contract again, They will all play the role of a belly. The shipper is the beller who is delivering the goods for a particular purpose, that is transporting the goods from one port to another so that it reaches the consignee. So the shipper is the beller. The consignee is the person who's accepting the goods on behalf of the shipper, and all the other parties who are helping them are the belly in the transaction. Okay, so this is what bailment is when it comes to your shipping business. Yes, so I'm having a couple of questions that I see in the chat. So there are that is the risk transferred, or there was something which has come before? Does that mean in bailment there's a mutual understanding only and cannot be abided by law of contract? I've not really understood this question, but when we come back to that, we will goods to the belly for a particular purpose without transfer of ownership. Oh my God, somebody has run too fast in the entire conversation of bailment. Okay, yes. So if we have understood the basic of what a bailment is, then we can move ahead and take, these other questions that we were speaking about. So stop sharing. Everything is gone. Yes. Uh, all of y'all who are into the shipping business, who are agents, who are agents in the sense who are working in an organization. You all must have gone through this kind of transaction. Would witness to these kind of transactions very often in your day-to-day functioning of business. Okay, so you all would probably be able to understand what exactly bailment is. But for the rest of you all who have perhaps not, who are freshers and who have not really seen this business, I hope it is clear to you all what I'm trying to say from bailment. And very simply, I will like to once again put it very, very simply across to all of you all. Bailment is a transaction in which one person delivers the goods to another person, but not for that other person to own the goods. Okay, it is only that one person is delivering the goods to another person for some purpose, and once that purpose is accomplished, the goods have to be returned either to the person who had delivered the goods or to somebody whom that person has assigned to take the delivery of the goods. Okay, so very often in this very simple transaction of a tailor also, you have given your clothes to the tailor for stitching, but not necessarily you go to take the delivery of the clothes. Okay, you may send somebody else, your friend, your relatives, somebody who's staying close by, who you will send, and the delivery of that thing is done to that person. Of course, you will inform the tailor that so and so is going to come and take the clothes, because otherwise the tailor may not want to send the goods to that. In the similar situation over here, in your shipping business also, the shipper is sending the goods to somebody whose name has been mentioned as a consignee who's going to collect the goods. Now the consignee will appoint an agent to go and take the delivery of the goods from the port, and the agent will collect the goods on behalf of the consignee. So the consignee may not go in person, but there is everything there. All letters of authorities are there, so that the person who is giving the delivery of the goods to the final person who's taking the delivery back from the baler, is aware of whom the goods have to be handled over to and whom not. Okay. So simply the transaction of delivering the goods from one person to another, and after the purpose is accomplished, the goods are returned back. Okay. So there is no ownership that is created in this. Okay. Or there is no passing of the property from one hands to another. When we say passing of the property, or when we say passing of the title in legal parlance, it means passing the ownership. Okay. Here, what is passing? Only the possession is passing. It was in my possession, now I'm giving it to somebody else, and now it is in somebody else's possession. And then it will go into somebody else's hand, so it will be into somebody else's possession. Okay. But I am the CH, and for the CHA to own those goods. Okay, so there's no ownership that is transferred. Okay, now on the consignee, where the ownership of the goods is transferred from the shipper to the consignee, that is governed by the Sale of Goods Act. That is not governed by the Bailment Act. Okay, over here in the or the contract of bailment. Contract of bailment is basically between the shipper and the CHA and the port authorities. And the port authority, and then again between the port authorities, the CHA, and the consignee to take the goods. Okay, but there is no ownership that has been transferred. The goods now, since the goods have gone in the hands of the CHA becomes the owner of the goods. Now it has gone into the ship, so the ship owner or the charterer or whoever it is becomes the owner, or the port authority becomes the owner. It is not like that. It is just that the possession is transferred, so that when the purpose is accomplished, the goods are sent back to the person who's supposed to be receiving the goods. Can I request this person who's there's someone called Shri who's asking a lot of questions. I understand your apprehensions. I understand your excitement to learn about the subject, but let us first understand of bailment. After that, we will speak about risk and destroyment and this, that, and the other. Okay, so please hold your horses. We are coming to that. Let us first understand what it is. Because if we are going to speak about everything in one breath, then that may not be understood by others. Also, remember that there are people who would be pretty fresh to the subject, pretty fresh to the entire parlance of shipping. I have a lot of students who are like that, and in fact, we have also been instructed by the college that we have to, or the institution, that we have to take care of those that set of students also. So let us be a little mindful. And yes, I'm not saying that I have stopped. The topic is over. So let us reach there, and then your queries will be solved. So I hope we have understood what bailment is, to the extent of what is the transaction of bailment. I hope we have understood that before we go ahead and speak about what are some of the the features of bailment or essentials of bailments, etc. Now, as I have been talking about all other specific contracts, like we spoke about guarantee, we spoke about agency, all of that. Similarly, bailment is also a special contract. So if it is a special contract, it has certain essentials which are apart from those that are there for a general contract. But that doesn't mean that all the essentials of a general contract are overlooked. All the essentials of the general contract remain in place, or they are there intact. And apart from those, there are some other essentials to the contract too. I will repeat the essentials of general contract, and they are a lawful, a valid proposal, a valid acceptance. There has to be a consideration. There has to be free consent. The parties should have the capacity to contract. The contract there has to be a legality of object, and it should be a lawful contract or a lawful transaction. Okay, so all these points also hold good for the contract of bailment. But apart from that, what are the essentials of the bailment? Are that there are two parties in the contract of bailment, and now there could be multiple bailers and there could be multiple bellies. Okay, but the parties are only two: a bailer who is giving the goods to somebody, and the belly who is accepting the delivery of the goods, accomplishing that purpose, and returning the goods back to the bailer or his. So two parties. So in the contract of guarantee, how many contracts were there in the contract of guarantee? Correct. What were these three contracts? So that we also revise a little bit of guarantee. A contract between the principal debtor and the creditor, contract between the creditor and the surety, between the principal debtor and the surety. There were three contracts. Unlike that, here there are only two contracts, similar to how there were two contracts in agency, or one contract, sorry, there's one contract, how there was one contract in agency and how there was only one contract in indemnity. Okay, so here also there's just one contract between the bailer and the belly. Okay, the very important essentials of this bailment is that first and the foremost, the goods for a purpose. Okay, sold and disposed of that way. There is a purpose for which the goods are delivered, and there is a delivery of goods. So these are the two very, very essential elements of payments. Delivery of goods for a purpose. Like I had, when we were doing indemnity, I had said that, you can perhaps write somewhere, indemnity is equal to loss. That is, when there is loss, then there is indemnity. The contract of indemnity will hold good. Okay. When we speak about guarantee, it is about giving surety to somebody that if his money is lost, then there is somebody who is going to give that surety to that person. Okay. And in agency, we had seen that there's a person who's acting on behalf of somebody else. Okay, so that was the purpose, to act on behalf of another person. Over here, likewise, in bailment, it is the delivery of the goods for the purpose. We have done indemnity, after which we did guarantee. Okay, then we did agency. Typically, when we were doing all these transactions, we have seen when we were doing all these contracts, when we spoke about guarantee, we also did speak in that guarantee also there is a contract of indemnity that plays a role. Okay, because if let me just go back a little back to guarantee and explain. In the contract of guarantee, there's a principal debtor and a creditor. The creditor has given money to the principal debtor. Okay. Now, if the principal debtor is not paying the money to the creditor back, creditor is losing the money. So there is loss that comes there. Loss that is coming in the picture. The contract of indemnity comes into picture there. Correct? Principal and agent, when we were speaking about the agency contract, also principal and agent. The principal is transferring some of his goods to the agent for the agent to do the needful, that is, sell the goods or something like that. So in that transaction, if the goods, like we also spoke about from the shipping parlance, we also said that, the shipper is giving the goods to the agent and the agent is then giving the goods to the, loading the goods in the ship. Okay. Now, if the ships are of dangerous nature and if it is not disclosed by the shipper that the goods are of dangerous nature, then in that situation, what happens is the goods may explode or whatever may happen, and that will damage all other goods. It can also damage the ship. Okay, so here also there's a possibility of loss, correct? And where there's a possibility of loss, the principle of indemnity will again come into picture. Correct? Understanding. So in all these special contracts, somewhere or the other, there is a sort of a scope for the other contracts to also play a role. Okay, there is a scope for the other contract also. So I always say this, and I've also said this previously in your class too, that when a matter, when a suit, when a case, simply we call it a case, court mein kya gaya, case gaya. You have taken the case to the court. Okay, so when there's a matter or a suit heard in the court, we are speaking about one act. So we will keep only that one act in the mind, and we will say that, okay, if this is the case, then in this case, these are the things that have to happen. That is, we have to only look at it from whether the delivery of goods was done or no, whether there was a purpose or no. But we are only looking at it from the bailment perspective. But the judge looks at it from a lot of other acts perspective also. So there's a holistic view that is given to a particular case. The judge will try to find out, and not just the judge does the job of giving a verdict, but the lawyers, when they are pleading, they will also see to it that what are the provisions of the other laws that can be applied to this particular matter, that can come or become a subject matter for this particular suit. That it is looked upon in a holistic way, and then matter is argued, and then the matter is also decided upon. So when we are speaking about bailment also, there will be indemnity that will come into picture. Because if the shipper is delivering the goods to the, sending the goods by ship, the bailment, the beller is sending the goods by ship. So perhaps the ship owner or the charterer is the belly in whose custody the goods are, and then he is delivering it to the consignee, who is the agent of the goods. So in that situation, also there is a contract of indemnity that will come into picture, where the beller or the shipper will have to indemnify the ship owner that can you go on mute, please? There is somebody whose sound is very loud and clear. Sorry, thank you. So yes, so there is a contract of indemnity also that plays a role in case of bailment. When the beller is delivering the goods to the belly, the beller is also giving a sort of an indemnity that if there is any loss that happens, because you are using these goods, then perhaps I will make the loss good. Okay, so that's also there, but all that we will see later when we are going to look at the rights and duties of the bellers and belly. That is the time when we will actually look at all of this. So the essentials of the bailment here, what we are seeing is that there are two parties, there is one contract, there's a purpose, there has to be delivery of goods, the goods are delivered, there's no transfer of ownership, but there's a transfer of possession. The goods are in the possession of somebody else now, it is no longer in the possession of the beller, and the goods are given with the purpose of the return. Okay. Before going into the rights and duties, yes, the shipper is the owner of the goods, and the shipper is sending it or delivering the goods by ship so that it reaches the consignee. Okay, So the consignee is also playing a role of the beller over here. He is accepting the goods on behalf of the shipper. Okay. So yes, but consignee receives the goods, correct? Sanjeev Tiwari had raised his hand also. So was it for this question only?
Consignee refers to belly also. No?
I didn't get you. I didn't get you. I did not get you.
Ma'am, the consignee is also belly.
Why would the consignee be a belly?
Because he is receiving the something from the shipper.
Why is he receiving it something from the shipper? Is the consignee going to return the goods to the shipper?
No, ma'am.
No, na. So what did we say about bailment? About bailment, we said that bailment is a transaction in which the goods are delivered and for a purpose, and the goods have to be returned back. Correct?
Yes, ma'am.
The contract between the shipper and the consignee is not of bailment, it is of the sale of goods.
Okay.
Hope you're understanding. I hope you're agreeing
Yes, ma'am.
to it also, not just understanding.
Yes, ma'am. Thank you.
Yes.
Thank you, ma'am.
Yes, that is the contract between the. So anybody else who had this doubt, please make it clear why I am not calling a consignee a belly is because when the consignee becomes a belly, what the consignee needs to do is to return back.
Return back.
Correct?
Yes.
I see that question, ma'am, is the consignee a beller or a belly? So now you have to tell me, Ocean, you have to tell us, what do you think? Who is the consignee, a beller or a belly?
Ma'am, consignee is the bailey. Sorry, baler.
May not be a baler in the complete context, but he's the agent or he's the person whom the shipper has authorized or the beller has authorized to take the custody. If you see the definition, we have seen that the goods could be either returned back or it could be disposed. That is, given to somebody else whom the beller has chosen to take the delivery. Okay, and that's the reason why I'm not calling the consignee a belly. Okay, I hope you all are understanding this. This is the crux of the contract of bailment. If you understand that the person has to return back the goods, then you have understood bailment.
Absolutely, ma'am.
Yes,
ma'am.
I hope.
Thank you, ma'am.
Yes, most welcome, everyone. Okay, now I will come to these things of Kinjal. Does that mean in bailment there's a mutual understanding only and cannot be abide by law of contract, written agreement? See, law of contract, we have always said, Kinjal, if this is not your, if you have attended the classes before, we've always said that a law of contract does not make it mandatory for any transactions to be in writing. Okay. When we speak about expressed transactions, okay, expressed transactions could be also expressed verbally. Okay, so it does not mean that there has to be in writing. Tell me, in this very simple example of a tailor and us, is it anything that is in writing? Sometimes the tailor even doesn't give you the bill or the receipt, whatever you call it, the tailor just takes because there's a mutual understanding between you and the tailor that you're going to give him for that purpose. He has opened his shop for that purpose, correct? So it is implied that that is this agency. Like for instance, we always speak about this one example, and this is not with respect to bailment. Please don't get me wrong in that thing. It's not in terms of bailment, but it is in terms of a quasi contract. You sit into an auto rickshaw, or you sit into a cab, or you get into a bus. Is that auto guy going to tell you, if I'm going to ride you, you're going to pay me? Is the cab driver going to tell you that बैठना है तो पैसा देना पड़ेगा? They're not going to tell you that, correct? You know that it is implied कि भाई अगर तुम रहे हो तो तुमको पैसा देना है, correct? Similarly, in this also, it is where there is bailment, also in the contract of bailment, it could be expressed or it is implied that it is an agreement. But yes, there has to be a mutual understanding in any contract. The contract starts with proposal and acceptance. If that is not there, there is no contract only. Now, this proposal and acceptance need not be in writing. It could simply be implied proposal and implied acceptance. Okay. I hope, Kinjal, I have answered your question. If not, I'm not going to spend too much time over here. We can connect post class and we can speak about it.
Madam,
Act of delivering goods to a belly for a particular purpose without transfer of ownership. Yes, somebody has.
Madam, if the contract is not written, then how can it be a law? Like there will be anything a law related to it, because it is not like in a written. So then
That is exactly what I have been speaking about, or I have been telling in all my classes. You know, where there is no written contract, it
exactly.
if you're going to the court, if I have entered into some contract which is not written, and if I am going to the court to sue the party, you know, the other party who I feel has done some kind of a harm or damage, it becomes my responsibility to prove them. I have to gather all evidences. So it becomes a difficult task, but it is there. Just because you don't have something in writing, the other party cannot say kidhar hai, likha kidhar hai. Show me where it is in writing. It is not in black and white, so it is not a contract. It is not like that. I still have the right to go and sue that person. If I'm able to prove that, you know, yes, I had given my clothes to this tailor for stitching, see what he's done of my clothes, or he's not given my clothes. You know, if I have that kind of a thing that I can see for one cloth, nobody is going to go to the tailor or go to the court. But when we are speaking about commercial law, we have to understand that in commercial law, the transactions are of crores of rupees.
Exactly.
When the shipper is sending the goods, of course, there's a bill of lading that you call about. Or, you know, there are so many things, documents that are done. I have also said this. I do not really belong to the shipping industry, but because I'm an HR person, basically, I'm a legal person. I'm an HR person, but not a shipping per se person. But I have clients who are exporters, and I see, you know, the rigorous processes they go through when they are sending their, you know, and they're all, most of these clients of mine, they're shipping their goods by sea, because sea is
Exactly.
It takes a lot of time. They're all shipping their goods by sea, and I see those kind of, you know, procedures that they go through while sending, after sending, you know, after sending also, when they have to get the money also, you know, those banking transactions and that MEIS, you know, refunds and all of that I have heard of, and I know about all of this. So definitely when we're speaking about shipping, this thing of nothing not being in writing is not commercial transaction, is always there in writing. But when we say that writing is not required, we are simply mentioning it because people should know, or the law says that writing is not required, is only because parties should know that only because there's nothing in writing, we have lost the right to fight for a particular thing. Okay, so let us not waste time on that, and I'm going to straight go to the duties and rights of the beller and the belly. Some answers that you must have not got here, you will get in those rights and duties. I will request everybody to not speak directly now. If you all want to talk, please raise your hands, mute yourself, or put your questions in the chat, because otherwise it will become disturbing when we are speaking about the rights and duties. Okay. So first and the foremost, we are going to speak about the duties and rights of the belly. Who's the person? Who's the belly? Belly is the person to whom the goods are delivered. Okay, the goods are in the possession or understand that. If you have understood that, then it will become very clear for you to understand the rights and duties, because they're very simple. There is nothing, which is confusing in these rights and duties. Very clear and very simple. The first duty is to take reasonable care of the goods billed. So when the shipper is sending ship to be delivered to the consignee, what is his one expectation is that the goods have to be taken. Okay, the goods should not be destroyed. The goods should not be eaten by rodents. The goods should not be set on fire. Oh my God, even I want to eat biryani and Colombi. यार please मैं Google पे नहीं करने वाली हूँ. मेरे घर पे पार्सल भेज दो. गणपति भी खत्म हो गए, हमारे घर के तो चले गए, तो we can eat. Please go on mute. Please go on mute. I understand that sometimes we just falter in that way. Okay, that was on the lighter note, guys. I'm feeling hungry. Okay.
mic बंद कर वाला इस सब कितना है मैडम?
Yeah, please. Also, you who's this? Please mute yourself. Also, who's this? I can't see the name. Who spoke just now? Please mute yourself. Okay. So, duty to take reasonable care of the goods billed is one first very important duty of the belly. The second is not to make unauthorized use of the goods billed. Okay, cargo mein se goods are going. It is difficult to open the consignment and all that. It's not such an easy task, but for some reasons, if the goods are easily accessible also, people cannot make use of those goods. That is, the people in the ship cannot make use of those goods that have been shipped by the beller. So for instance, the tailor ko kapda diya hai for him to stitch it into a kurta. He cannot say कि एक दो बार मैं पहन लेता हूँ and then I will return it back to the beller. Okay, so duty not to make unauthorized use of goods billed. Okay, duty not to mix beller's goods with own goods. Okay, in this also may not happen in case of your in the shipping parlance, but yes, mixing up of cargo is something that can happen. We always see, not always is the wrong word, and you all will all pounce at me and say, you think our operations are so bad. But sometimes it so happens कि किसी का cargo has reached somebody else. That is something that sometimes can happen. There are markers, there are numbers that are given, codes that are given, and all that. But in such huge operations, like बड़े-बड़े शहरों में छोटी-छोटी चीजें होती है, in that बड़े-बड़े on the port there is humongous operations that are happening. There are so many ships that come, vessels that come to the port. There is so much of cargo that is what you call unloaded, downloaded. I'm saying unloaded from the ship. In that sometimes it happens, and sometimes a possibility that the goods may get mixed. Okay, so that should not happen. Tomorrow, the port authorities cannot say that that is not yours. They are the same goods that other person has also sent. So, no, what is there? You accept this consignment. No, if I have been sent some consignment, I need that consignment. No matter how identical the goods that you have given me, I have the right to sue you. Okay, because it's your duty. Duty to return the goods upon the accomplishment of the purpose. Okay, the goods, the cargo that has been sailed needs to be given back to the consignee, because the consignee is the person who is going to take the cargo. But yes, there are other things that will come into picture. Freight is paid or not. What are some of the other things that the consignee has abided by or not. Similarly, the tailor will also not just give away the kurta that he stitched for you unless you have paid him money. Utna right to belly ka banta hai, that we will see when we are seeing it below. Okay, but it is the duty to return back. If the belly has abided by his duties, then it is the duty of the belly. If the beller has abided by his duty, then it's the duty of the belly to return back the goods. Okay. Duty to return the beller the increase or profit on the goods. What has happened on the goods? If there is any profit that has accumulated on the goods, even that has to be returned back. What is an example that you all can think of? I know of one example, but what is an example that can typically happen on the ship? The examples that I'm going to speak about are all land-based examples. I'm asking you a ship-based example. The beller or the shipper has delivered something to you. I'm not even calling it goods now. They have delivered something to be sailed and transferred to another, or the beller's agent is going to come and collect the goods. Okay, and that whatever has been shipped on the ship, there is an increase in that thing. That increase also needs to be gone to the what could be an example of that?
Livestock.
Exactly. Who's this? Who said that?
Yeah, that's me.
Okay. Because I can only see this screen, I can't see you guys, and that sometimes makes me very irritable because I like to see who's talking. I like to respond not like this as if I'm speaking to some wall only. But yes, livestock, correct. Livestock, there is a production, correct? Where there is a possibility that you have sent, for instance, you have sent sheep has delivered a car. What is the small one of a ship called? Also, I'm forgetting now. But whatever it is called, please. I don't want to get into English grammar now. Okay, that little one has come. What happens is it becomes the duty of the in which that act has taken place to return back the small one of the sheep also to the consignee, the representative of the shipper who is going to take back the livestock. So very simple examples of all these are, you are giving, you going out to your native place, you have plans. All these, if you look at law books and if you start looking at them, all these small examples are given in the law books because it is very important to understand the concept. Understanding the transaction now at your point, or in your thing, it is all right to understand the transaction because you all are working professionals, you all are doing all this day in and day out. But when these things are taught to undergraduate students who do not have any clue about how the commercial world actually runs, for them to give examples, there are small examples that are quoted in the law books. Anybody who studied law here would appreciate and will recollect reading these examples. Okay, so small examples like you are going to a native place, you have plants. What you will do is you will give your plants to the neighbor so that the neighbor waters the plants, because if nobody is going to water the plants for 15 days, they will get dried. So you're giving it to the neighbor so that the neighbor waters the plant. And when there are flowers or some fruits that the plant bears, so when you come back, the neighbor has to return back the plants and flowers with an exemption to this. An exemption to this would be if the flowers have rotted or if the fruits are going to rot, then maybe the neighbor can make use of that, because otherwise it's going to rot. But back the plants to you with all the additions that have happened to the plant. Okay, so any increase also needs to be returned back. That is the duty of the belly. Let us now look at what are the rights of the belly. The right to recover necessary expenses incurred on bailment. There's a right to recover the necessary expenses incurred on bailment. Very, very typical example of the tailor again. Okay, you have only given the tailor a piece of cloth. When you're making a dress, there are other things also that are required. Maybe buttons, maybe a zip, maybe sometimes a lining. Correct? All that is also required. when all that is required, very often you are not the one as a beller who is going to give these things to the belly. Who is the belly at his own expense is going to buy these things, and then he bills all that cost to you. Correct? That is the time when you will have to. So that is the right of the belly to recover that amount from you. Okay, the belly can say that okay, I'm going to buy the buttons, I'm going to buy the lining, I'm going to buy whatever other things the tailor will say, and you will say, okay, you buy it, I will pay you the money. So it is the right of the belly to recover necessary expenses incurred on bailment. Okay, like for instance, if you are sending goods which require specific, there are specific requirements of the goods when you are sending by cargo, and if the ship owner or the charterer, whoever it is going to make provision for that, those things that are required to take care of your goods, you will be charged for that facility, correct? And if you're charged for that facility, it becomes the right of the belly to recover that thing from the beller, that amount from the beller. The second right is right to recover compensation from the beller. Obviously, if you have asked the tailor to stitch the goods, the tailor is going to definitely uh, what you call it, take charge you for the expenses that has happened. Okay, and right of lien on the goods paid. If the freight is not paid, if the money is not paid, then in that situation, the belly will have the right to create a lien and not return back the goods until his expenses until his compensation is paid. I see one hand raised. Already in possession of the Yes, if a person already in possession of the goods of another contract to hold them as such goods, although that's a direct message. The owner becomes the bearer of such goods, although they may not be delivered by way of bailment. I've not really understood this. If a person already in possession of the goods, Anurag, you have sent this message to me directly. Doesn't matter. Can we take it? Can we take this question in the break? I will need to ask you some questions. So here people cannot see this question. So let me ask you. Let us do that in the break. And there is a question. Who's that?
This duty to return the bill at the increase base. Can this apply to shipping also?
I can't. I didn't get you. I didn't get you. Who's this? Is it Anurag?
No, ma'am. This is Sanjeev.
Sanjeev, I didn't get your question. Please
The last. Okay, ma'am. I will ask later.
Yeah, just wait, because I'm addressing somebody else's questions here. Okay. And then there is a question from Vikas who's saying, ma'am, is the belly will be in change time to time? I didn't understand this question also. So maybe, you can elaborate on this question, Vikas. You can write an elaborate question on the chat. Sanjeev, you were saying something. What is it that you have not understood?
Point of duties can be applied.
Yes, somebody gave the example of livestock, no?
Yes, ma'am.
shipping also, no, if livestock is going, if there is a sheep, okay, let me take an example of a cow. If a cow has given birth to a little one, that young cow will also be transferred to the beller, that is the consignee. So everything, see, if there is a contract of bailment, whether it is the shipping industry, the automotive industry, or any sort of industry it will hold good if it's a law of contract. I mean, if it is the contract of bailment, then all these duties will be applicable to the bailor, and the rights also that are here. So we are going to see the rights and duties of the bailor also now very soon. Okay, so where there is a contract of bailment has been established, all this holds good for anybody. It is not just shipping industry or any industry, it's for all industries. So not paying freight, now it depends upon who's going to pay the freight and all of that. If to the consignee, okay, then the port authorities will have the right to hold on the goods. And we are going to see, when we are going to speak about the Major Ports Act and the all those things that we stage to such goods which are not claimed by the consignee for not paying freight and all. What happens to those goods? We will be speaking about all of that. Okay? We will also be speaking about, somebody had asked about destroying and destruction and all of that. That also we are going to speak in that particular portion of our syllabus. But so rights, duties and rights of belly is something that we spoke here. To make it very simple for you, the duties of rights of the beller will be just opposite. The duties of the beller will become the right of the the duties of the belly with some chota mota changes here and there will be there, and the duty of the beller. Okay, let us have a look at that. So duties and rights of a beller we are going to speak about now. Duties. Okay, if there are any faults, if you go to the washerman or the laundry guy, again, let me take a very simple example. He clothes. If there are any stains and all beforehand. Why he does that is because after he's done the service, and you say that arey, ye to fata hi nahi tha, there was no holes now. How is it that there are stains in this now? No, there's a possibility that these things happen, and that is the reason why it is mentioned in law that it is the duty of the beller in the goods. So not just faults. Let us, from this shipping parlance, let us look at hazardous goods or dangerous also. Even if goods are hazardous in nature or dangerous in nature, they can still be shipped. Okay, the only illegal goods cannot be shipped. Illegal goods are goods which the person doesn't have the title or to. He's not the owner of the goods and he's shipping somebody else's goods, which is by fraud, cheating, or whatever. Those goods are not allowed to be shipped. But dangerous goods, hazardous goods can also be shipped. But there are certain rules and regulations for shipping dangerous and hazardous goods. The shipper has to disclose that the goods are of hazardous nature, they are of dangerous nature, so that the what you call that, the ship owner or the charterer will either tell the shipper that we do not have provisions to carry such goods, okay, or they will make provisions to carry such goods. The agent will tell the shipper that these goods will not be carried by this kind of a vessel. It can be carried by the other kind of a vessel. So even when you're sending, when people are sending drugs like, pharmaceutical products and all of that, it needs certain times, it needs to be stored in, certain temperature, the goods that have been sold. It needs to be sold in at certain temperature. So if a vessel does not have provision for, that kind of a storage, it is the duty of the vessel owner to make the beller known that the vessel does not have that kind of a facility. Okay. Similarly, if there are any dangerous goods, hazardous goods that have to be shipped, there's somebody's sound that I can hear. Please go on silent. I don't understand what is the necessity to unmute yourselves if you all are not asking the question. And I have told you all, please raise your hands so that I will tell you whether to unmute yourself or not, because it's becoming very disturbing for me in between. Okay? So duty to disclose false is one. The second duty, I can still hear some sounds. Irfan sir, please just have a look at who is there on unmute and please mute everybody.
Yes, yes. Done.
Yes. Duty to repay belly's expenses. Okay. So the belly has incurred certain expenses for the purpose for which the goods were delivered to the belly. Like I said, the tailor's example, very typically, the tailor has bought buttons, has bought zip, has bought lining and all that. So it was the right of the, I've come to the previous slide now, duties and rights of the belly. Right to recover necessary expenses incurred on payment. It is the right of the belly. Here it has become the duty of the beller. Okay. The next is duty to indemnify the belly. Indemnify, like I said, when the shipper is sending the goods, the shipper will have to indemnify the vessel owners or the charterer that the goods that I am sending are not of dangerous nature, they are not of hazardous nature, they will not actually create any harm to any other goods that are there, to any people who are there on that, on that cargo vessel or whatever. So they have to indemnify, and if there is any loss that occurs because of the goods that they are sending by this particular vessel, if there is any loss that happens, we will make the loss goods. The shipper will have to indemnify that if there is any loss that happens or occurs, it is my responsibility. It is the shipper's responsibility to make that loss good. Okay, that is the duty to indemnify the belly. Okay, so all those questions which had come in terms of destructions and all that, now we know that it is the beller's duty to indemnify the belly. And as against that, what is the duty of the belly? The duty of the belly is to take reasonable care of the goods paid. That is, the vessel owner's duty is to see that he's taken reasonable care of the goods paid. Now, yes, you must have learned somewhere in the, in COXA, that is carriage of goods by Ship Act and all of that, you would have learned that it is only the responsibility of the vessel owner or the charterer that they see that the ship or the vessel is seaworthy. Okay, it stands there. We're not going to get into all that when it comes to the act of bailment or the contract of bailment. If such a matter occurs, where one has to prove whether reasonable care of the goods sold, of the cargo sailed was taken or not, then when the matter will go to the court, all these things will come into picture. How was the reasonable care taken? Was the vessel seaworthy or was it not seaworthy? Okay, so all those acts will again come into picture. I hope I am making sense to you when I'm saying that. But yes, it is the bailie's duty to take reasonable care of the good, and it is the beller's duty to indemnify the belly against any loss that will. Okay. So again, like I said, duties here and duties there that are there. Duty to compensate belly for breach of warranty. Okay. If there was any warranty that was given, warranty, see, conditions and warranties is something that we will be speaking in the Sale of Goods Act. It is not as simple as you buy a thing and you get a warranty of 2 years. 2 years may agar, if you know you bought a television, 2 years may, if the tube of the television is gone, then we will replace the tube. I don't even know now whether there's a tube that comes. What is the technology of television? But I'm saying about this tube when we were young and all, when we were small, not even young, it's ages now. I am old. So when we were young, you know, we used to have those tubes, and what tubes used to often go, and then we used to have to replace the tube. So there used to be a warranty of 1 year, 2 years and all. But when we will be speaking about warranties in the next chapter immediately, that is the time when we will understand. So let us hold this concept of warranty over here. We'll speak when we are going to speak about that. Okay. So duty to compensate belly for breach of warranty. And the last duty is duty to claim back the goods. Okay, the beller has given the goods not for the belly to become the owner of the goods, but only for certain purposes. And that purpose, once that purpose is accomplished, then the goods will be returned back. Manpreet, you want to ask the question directly, or have you put it in the chat where I can read and I can answer?
I want to ask a question.
Bolo.
What is the cargo that's polymerized or something?
The voice is cracking. Hello. Manpreet,
You're not.
Manpreet, your voice is cracking.
Hello?
Manpreet, your voice
Check
is
the
breaking.
cable. Check the mic cable.
A lot of people might not know that assignment of live animal cargo like cows, goats, ships, etc. Yes. Thank you, Swapnil, for that explanation. Thank you. We can change belly. I've still not understood this question of Vikas. Because we can connect later and you can ask me the question directly. Yes, Manpreet? Clear, or you will put it on the chat? I can see Anurag's hand raised. Anurag, you want to say something? So Manpreet, have you put your question in the chat? Okay. What if the cargo get polymerized? Whose duty it becomes to take care of it then? Manpreet, honestly, I don't understand what you mean by polymerized. How can you explain how? Then we will be able to say whose duty it is to take care. Polymerized in the sense how and okay, till then we will go back. Maybe we can speak about this. As if it gets spoiled, no, yes. So it depends. That's what I said. Where were we? Wait. Where were we? Indemnify the belly is one, and here in duties and rights of the belly, we have seen duty to take reasonable care of the goods billed. So it will all depend on how the goods have got spoiled. Was it, whose fault was it that the goods have got spoiled? Did the belly not take enough care? Or did the beller not tell the belly what kind of care the belly needs to take? These are the questions that will be asked, and only after that it can be decided whose duty it is. Okay. The belly, if the beller is sending the goods by cargo, the beller, and if the goods need a particular kind of care to be taken, then the beller will have to tell or specify to the belly that this is the care that needs to be taken. That's what I was just speaking about when I spoke about this example of pharmaceutical, where the drugs need to be stored. Drugs needs to be stored at a particular degree of temperature. If that is not told to the belly, okay, then the belly is not going to know what is the requirement. Correct. If it is told to the belly and the belly has not done the necessity thing, or has not done the needful, then it becomes the fault of the belly to not take care of the goods. But if the belly was not told about this, then it is the fault of the belly. I don't know, Manpreet, if I've answered your question. You can just write in the chat. If you have anything more to ask on this, we can connect later on. Okay. What is it? Where were we? Compensate the, yeah, okay. Duty to claim back the goods. We spoke about that. Okay. Now, the rights of the beller. Okay. We've seen the duties of the beller. Now we have to see the rights of the beller. And like I said, duties of the beller becomes the right of the belly, and the rights of the beller will become the duty of the belly. So let us see what are some of these rights of the beller. Right to reinforce belly's performance. What is belly's performance? What is meant by belly's performance? The goods are given to the
To deliver the goods safely.
sometimes very funny things happen virtually. On my screen, I can see, and I can prominently see, because I can see the screen, I can prominently see only 4 windows. Okay. And of that, there is one window of a person. I don't know whether it is the photograph of that person or that person is there in the frame and sleeping. So, these people can either keep their videos off and go off to sleep, or I don't know whether it is just a photograph. But, it sometimes becomes very distracting to see such things. It becomes also very irritating to see such things. And sometimes for me, it becomes very annoying also. I don't know. I sometimes tend to lose my patience. I'm sorry about that. But we need to have some decorum in the class.
What happened, madam?
Yes.
Can I help you out? What some problem? I can check with the other participants here.
No, who's this? Imran?
Irfan from NMIS, man.
Irfan, sorry, yaar, why do I call you Imran? Irfan. No,
Yes.
no. I could see one screen on my, I can see 4 screen, out of which I could see one screen where I could see that person. I don't know whether is sleeping there, and it was really disturbing me, to see that. That's the reason why I made it a point. I would not like to see such things. We need to have some decorum in the class here. Even I'm feeling sleepy. Even
See, I have kept in the emails also in the links that please maintain discipline of a class, everything. Then also, I don't know why the students are doing like this. Please, student, please maintain discipline during the class. You do whatever you want to do, or else you just keep your videos off, or else I'll just remove it from the class. This is the final.
I don't want to mention names, but it becomes
Again,
very annoying to see.
Yeah, again, we can't tell you. You're all grown-up student. You are not a small children. Again, we have to tell you all these things. Honestly, what will happen? We'll just expel you from the class. That's it.
We are doing postgraduate diploma in shipping and logistic management. When we are speaking of the word management, we need to first learn to manage ourselves. If we cannot manage ourselves, no, it is useless doing all of this. If we cannot be a little mindful about how we should be professional in the class, then we cannot really become successful in our professions outside. But nice to see that. I'm extremely sorry. I'm sorry for the entire class for this outburst. But I'm seeing for sometimes. Okay, now it will change. Now it will change. To go glory, don't put your attendance for the sake of getting your attendance. It is not required. You're not doing a favor on us. You need to do a favor on yourself because you're paying money. We're speaking about right to enforce belly's performance. Okay, what is belly's performance? The goods are delivered to the belly for some purpose, correct? The belly has to do that and then deliver it back to the seller. Okay, so in case of simply when we were speaking about the tailor, the small example of the tailor, the belly to stitch that thing into that cloth, make that piece of cloth into a kurta, stitch that kurta or stitch that shirt and return it back. To enforce cannot come together and nahi kar sakta. That cannot happen. The beller has the shipper has sent his cargo to the agent so that the cargo is from one port to another. The agent has kept the cargo and now saying that maybe I'll not be able to do it. That is not done. Okay, it is the right of the beller over here to enforce the belly's performance. It is the right of the beller to see to it that the belly is transporting the goods from this from him or this port to the consignee, where the consignee is going to take the goods, because these are all commercial transactions again, correct? Why is the shipper shipping the goods? The shipper has, and in 90% goods, because the goods they're sold to the consignee. Okay, if the goods are not shipped by the belly, that is the port authorities or the ship owners, the charterers, or if the agents have not taken necessary action to sail the cargo, then it is the loss to the beller. Bailey's right to claim damages if the belly has not taken proper care of the goods. Like Manpreet had just asked this question, whose duty it is. Goods in care of, then the beller will have the right to claim the damages. But if something that the belly will have to then prove, okay, then this right will not be enforced. But of course, say that it is taken care. That question he can certainly ask to the belly. Right to claim compensation against unauthorized use of goods. If the tailor has used the goods, and if you come to know that the tailor, you take compensation from the tailor. What is the compensation? How reasonable that could be mutually agreed? Seldom agreed. Then one will have to approach the court, and that is where perhaps things will be taken into consideration and what is a reasonable compensation that will be decided. And last but not the least, right to demand return of goods along with accretion to it, if any. So we saw in this the increase or this is the duty to return to the beller. So here it has become the right of the beller to take that accretion or that profit or that whatever extra that are bailed to the belly. So these are the rights and duties of the beller. On this, let us in 10 minutes. We will come back at 11:50. Okay. Anybody who has Manpreet, you still have a question?
Ma'am, I'm audible.
Manpreet, you're not audible at all. You're not audible. If you want to just write a direct question to me, you can please do that also, but you're not audible. I'll not be able to
Sure, ma'am,
answer you.
I'll just type it.
Manpreet,
Yeah, please write it in the chat.
Manpreet, what can you do during the break? You can just log off and re-log in again and check with the mic connection when it connects again to the session. It will ask you to connect with audio
Yes.
of the laptop or only the Zoom.
Okay, I'll just try it once. Hello. Ma'am, I'm audible now.
I can hear what you're speaking, breaks in between. But try asking, let's see. No, can't hear. Someone is saying, ma'am, I'm attending through my PC. I don't understand why is this message? Neelam, ma'am, I'm attending through my PC. So,
She's the one.
Hello, ma'am. I'm Vikas Kumar. Are you listening? It is audible.
yes.
Ma'am, my question is that in any consignment.
Answer to you, the belly will not change.
No, ma'am. Just one. There have consignment. There are lots of agents and lots of agency will work in any consignment, any cargo, any vessel. In that particular point, if his consignment to freight forwarding, right, to another. That point, the belly.
The person, who will you contact? Who will the shipper contact? All these are bellies. All these will play a role of a belly, but they will play a role of a belly to one another, not to the shipper. The shipper will finally, whose neck is the shipper going to?
Which he provide the freight forwarding any agency. Correct? Okay, ma'am.
Yes.
That was my question.
Questions I didn't really get. I have posted 2 questions about which are the 2 questions that you have posted? What happened which may have already answered that, I think, enough. That the beller will have to not, what happens when the beller is not aware of the, give me examples, I will tell you what it is. What kind of, I need examples for. So explain to me both your questions, but for 5 minutes and coming back.
Going on the Madam, this is Irfan from NMIS. See what you can do. You can switch to view as a speaker view. Don't go in gallery view or any other side by side. Select the speaker view, and there are 3 dots.
No.
Yeah, there. Okay, it's done.
No. Listen, Irfan, listen. I don't like to do that because you know what? I like to feel that I'm speaking with someone.
Then I understand. I got your point.
No, listen to what I'm saying first. Listen to what I'm saying first. And when I see at least 3 or 4 people, I feel that I am speaking to a class. But in that 3 or 4 people, when I see somebody like this, then it disturbs. And it is not, even if let me go on speaker view, I don't mind. Or let me just not go on any view. Students in the class should also learn to keep some decorum if they're keeping their videos open. And in the first class also, I had said this, if people remember, somebody was sitting with just shorts and, very inappropriate dressing. I had said that, either keep your videos off if you all want to sit like that. Because that is something that I'm very particular about. It takes efforts for all of us also to, to dress up, sit here like this. So that is not my point. What view I get is a different story. But I want people to have some kind of a decorum in class. That's just simply what I'm saying. I hope you understand that. Okay. So back to our discussion. We were speaking about bailment. We are going to continue our discussion on bailment. It is not what we're going to speak about now is not a contract of bailment. It is a contract of pledge, but pledge is also a type of a bailment. So remember or keep in mind that it is also a kind of a bailment for a particular reason or for a particular purpose. So like we first spoke about general contract, okay, and then from general contract we moved on to special contracts. Okay, then we spoke about indemnity, guarantee, agency, uh, bailment. Now from bailment, we are moving into a special kind of bailment. Okay, so it is the contract of pledge that we are going to speak about. That is also a contract of bailment, kind of bailment. So all characteristics of a general contract will again remain or hold good for a pledge, okay, and all characteristics of bailment will also hold good for a pledge. Okay, so let us see what a pledge is now. The bailment of goods as security for payment of a debt or performance of called pledge. Okay, bailment. what happens in a bailment and this is what happens in bailment. The bailer will deliver goods to the bailee for some purpose, and when that purpose is accomplished, the bailee will return goods to the bailer. Correct? That is what happens in one minute. Oh, my battery is getting exhausted. Give me 1 minute. Sorry. So this is what bailment is. Okay. Let us go back to the definition of pledge now. Pledge is the bailment of goods as security for the payment of debt or performance of a promise. Okay. And that is called a pledge. Oh, how do I do that? So, for this bailment, this particular bailment to become a pledge, what kind of a transaction should it be? It should be that the beller is delivering goods to the belly as security. Why would a beller deliver goods to the belly as security? Only if the belly has given the beller some debt, correct? So in pledge, when we speak about pledge, okay, the belly has given debt to the beller, okay? And that is why the beller is delivering goods as security. Correct? Then what happens in the same transaction? After the beller has repaid the debt of the belly, what is the belly supposed to do? The belly is supposed to return back the goods that were kept as security to the beller. Understanding the point? Okay. The belly has given debt to the beller, and so the beller is delivering the goods as security. Beller repays the debt. The beller has repaid the debt. Belly returns the clear? Beller is delivering the goods to the belly, okay, for some purpose. Here the purpose is security, okay. And why security? Because belly has given some debt to the beller. Once the beller has repaid the debt, what is the belly supposed to do? Return back the goods to the beller. Clear?
Yes, ma'am.
Okay. beller over here is known as the pawner, and the belly is known as the pawning. That is the difference. And the essentials of a pledge is, again, there is a delivery of possession. The possession is delivered, and the pledge is by hypothecation. So when you're putting you're giving something as security, it is known as hypothecation. You're hypothecating the goods to the belly. So we must have seen this in general kind of situations, where somebody is taking the loan and then you are giving your gold ornaments of something as security. Once the loan is repaid, then your ornament comes back along. This is the same situation. Okay. Now, so a pledge is also a bailment, but it is only for a very specific purpose of security. That is, goods are bailed for the purpose of security, and therefore all other things, all other rights and duties of the beller and belly, that is the pawner and pawnee, will remain the same. All rights and all these duties will remain the same. People who are working in the shipping industry, I would like to check with them. There are these two concepts, and please write in the chat. I don't want you all to say anything. Please make a little efforts to type in the chat. Uh, I don't know if you all have heard of these words, bottomry and respondentia. And whether you must have heard, I'm sure you must have heard if you're working in the shipping industry, you would have heard of these words. I also want to check with you, how much are these kind of transactions in use today in the shipping industry? Because as per my knowledge, bottomry, respondentia, these are old concepts, old things, uh, sort of insurances, again given, security given in the shipping industry, which were known as bottomry and respondentia. But as of today, there are so many, other sort of insurance schemes that are come, that these things are really not much in use today. But of course, we will understand the meaning of it, but we're not going to get into much detail because uh, I'm not really getting any answer in terms of bottomry and respondentia. Okay, so let's have a look at what they are. These are some sort of security bonds. Bottomry is used for security for the ship, for only the ship, the, what do you call it, the hull of the ship. Okay, and respondentia is basically for the ship and the cargo. These two things are. Bottomry bond is the contract for the loan of money on a ship. So let me give you we have spoken about this in the last class also. Let me again, just once again, speak about it or give you a little rough idea. Is vessel is at high sea. That is, it is sailing and it is much away from the port. It is much away from the owners, because the owners are on one port and the vessel is actually roaming all around the globe, and the owners would not be in close vicinity of the vessels. And like I said, all these terms, bottomry and respondentia, and these bonds, the bottomry bond, respondentia bonds, and all, these were used in the ancient time where technology, communication was also not very strong. In today's world, today's era, we all know that the communication has also become much stronger, much faster, more than stronger. It has become much faster. All your wireless communication or your internet communication and all that, it has become quite pretty stronger now. So connecting with the owners may not be as difficult as it was in the previous days or in the previous era. Uh, if anybody has any point on this particular discussion, please feel free to write in the chat or raise your hand. Maybe we can have a discussion on this, because that's what I feel, or at least I would be interested in talking about this. So today's era, it is slightly much easier to reach the owners, but in those days it was not really very easy to reach the owners. And the vessels also were not so technically sophisticated and all that the way they are today. That certainly doesn't mean that things don't go wrong today on the vessels, because the more sophistication, the more you need to handle it with care, and the more there's a possibility that there would be things that go slightly haywire. And when the vessel is at high sea, and then if something goes wrong, the master of the ship, of the vessel, is in charge of the situation, and the master sometimes may have no option but to connect with the nearby port to see to it that there's a smooth sailing ahead. You have to connect with the master will have to connect with the nearby port, or with somebody who can help them with things if there is any mishap or breakdown of machinery, breakdown of communication channels or something like that, for which the master may need money, and the master will want to make will have to pay somebody who's helping him repair the ship, repair the parts and all of that. That's typically the scenario that happens on ship. Did I have anything that's come in the chat? If there is no idea, please don't write on the chat here, please, because I'm going back thinking that I will get some good answers, and if I'm only have to see all this, it is like breaking my link also. Only if you have some idea, if you want to say something, please write over there. I know that everybody won't have an idea. I know that some of you all are beginners. So if you have not heard of that, you'll have not heard of that. Not a problem. Okay. So yes. So, and that's the reason why sometimes security is required, and a lot of those things are that the master may do certain things. The master will not have that kind of money actually with him, but he wants things to be repaired, to fall in place, so that the voyage further is smooth. In that kind of a situation, there's a possibility that he'll have to keep something as security, because why would somebody help him in that kind of in that particular situation, because he is going to then move ahead with his ship. He's going to sail and go carry on with his voyage, and then go miles and miles apart from the person who has helped him. So that person will need some security, right? So how is this security given if the master doesn't have enough money? He would have to either hypothecate the ship, or he will have to hypothecate the cargo on the ship, or he will have to hypothecate both. It depends upon what is the kind of money that he's going to incur. Okay, so for this, there were these kind of bonds that were there into existence, and of course they're not completely discarded. But now there are various other ways of insurance. There are various other ways of like I said, communication has become stronger. So there are ways of transferring money immediately from someone to someone, and all of that. So that is the reason why these bonds may not be really in great use today. But of course, yes, y'all can go back. People who are in the shipping industry can kindly go back and check. So this is a sort of a homework for y'all also. Y'all can also go and check back within the industry whether these bonds are still in use, and if they are in use, how extensively are they in use? Okay, so this first, and then you can take it forward from there. And like I said, we are not going to waste too much time on this. So bottomry bond is the contract for the loan of money on the ship. Okay, loan of money. There's some loan that is taken, and the ship is kept as a security. The ship is pledged as a security. Okay? A bottomry bond is usually executed for maritime risks encountering during a certain period or for a certain voyage. Okay? So the bond is for a particular period and for a particular voyage. Okay, it is not that once a bond, always a bond. It is not that kind of scenario. It is a bond will be entered into that if anything goes wrong, I will pay you the money and you will keep the ship as security. And then when that time comes, you will repay me back the money in this particular voyage or for a period of 1 year. Okay, such bonds are generally secured at extraordinary interest. The loan can be enforced only if ship vessel survives the voyage. Okay, if the vessel or the ship is fully damaged, then this loan will not be enforced. Even if there is a bond, the person who has agreed to pay the money as loan, lend the money, not pay. Sorry, pay is the wrong word. Lend the money of loan can raise his hand and say no, because the ship has not survived the voyage. We will not pay loan, because if the ship has not survived the voyage, then the security is the ship. The ship doesn't exist. So what is the security? Okay, so that is bottomry bond. The second type of bond is a respondentia bond, is a loan upon the mortgage or hypothecation. It is only a personal obligation on the borrower. It is not a specific lien on the goods unless there's an express stipulation in the bond. In case of loss, the loan amount to an equitable lien on the salvage. Confusing, right? For me also, not being from the shipping industry, it is slightly confusing to understand, but yes, let us try to break it down and try to understand it. So like in bottomry bond, the security is the ship. In respondentia bond, the security is the cargo. Now, whose cargo is it? The cargo is bailed to the ship owners, correct?
Ship owner.
It is not in the ownership of the ship owners. But yet, as per the respondentia bond, the cargo can be kept as a lien or can be hypothecated with the person who's going to pay the money. But it is only the personal obligation on the borrower. Okay, they will keep the cargo as thing, but if the as security, if the ship owner is not going to pay the money, then the cargo is there as security, and the cargo will not be given to the consignee until the money is made good, and then the consignee can sue the who's that? The ship owners. The consignee can then sue the ship owners if the cargo has not reached the consignee, and it is not a specific lien on goods unless there's an express stipulation. So there is this lien is in general. It is not specific on the goods, that is, these goods will be sold or these goods will be taken. It is just to make sure that one way or the other, the ship owner will pay back the money to the person who is giving him the money on loan. Okay, the cargo will then, in case if this person is not paying the money, it is not on specific goods, so definitely the cargo will be then given back to the consignees, because that is the right of the consignees to get back the cargo, but the amount of worth will be recovered from the who's that? From the ship owner who has taken the money in case if there has been any mishap or any sort of breakdown of the machinery or something that has happened. In case of loss, the loan amount to an equitable lien on the salvage. That is, if the ship is completely destroyed, okay, I will not say completely destroyed in this case because if there is salvage, have you all heard the word salvage before in any of the things, or even generally, salvage is something that is saved. So even if the ship has got destroyed for some reason, there would be certain parts of the ship, or there would be some part of cargo that has been saved. Okay, so the loan amount that is given in case if something needs to be repaired in that kind of a situation, or if something needs to be taken care of, the loan amount that will be given will only be given on what is the amount of salvage that has been recovered, what is the amount of the goods, and maybe the the parts of the ship, or the furniture and fixture on the ship that is recovered, what is the worth of all that salvage, only that much amount will be given as loan. And of course it is completely the duty of the ship owners to make this to repay this loan. Even if the cargo is kept as mortgage, it is not the responsibility of the consignee to make good this loan, or the consignee is going to get the cargo back, because that is the duty of the consignee. It is just that it was kept as it is kept as hypothecation, so that there is some security that the person will have. And unless the ship owner is not paying back the money to the person who has given him loan, the cargo will not be given to the consignee. So it becomes an obligation of the ship owner on the consignee also, because the consignee will otherwise sue the ship owner for taking back the cargo. Okay, but like I said, now there are various other modes of insurance, and of repaying back the loans, and all of that. And that's the reason why these kind of things, so wherever you read, or if you try to understand also, pottery, respondentia, these were the things that were used as old kind of hypothecation methods and all that. I do not really hear of these in today's era that much. I have got something on the chat. Let me just see what are some of those things that have come on the chat. Sorry. Just chat. Okay, so there's a question. What kind of a loan are we talking about here? Is it the obligation of the belly towards the beller? No, it is not the obligation of the belly towards the beller. It is not the obligation of the belly. Sometimes when the ship is in high sea, and if the ship occurs some kind of trouble problem, then in that situation, master of the ship needs to the master of the ship needs to repair the ship. If there is a mishap that has happened, if there's an accident, master of the ship will have to undergo salvage operations. Okay, so salvage operations, and for salvage operation also there has to be some money that the master of the ship will need. For repairing the machinery also, there has to be some money that the master of the ship will need. All these things, for all this, for a lot of things, the master will I will close the chat because there are too many questions that come and I get distracted. So for all these things, money is required. Now the master will not have all that much of money along with him, correct? Because the master will not keep that much of money also, because we all know about the pirate operations that happen, and all of that. So it is risky to carry so much of money along with them also, and hence the master will go with limited money, and
Insurance.
and then he may require money, and when he requires money, then there are these bonds that are signed between certain parties, in the sense the ship owners and certain parties that, this in these kind of situations, money will be, given to the master wherever, whichever, or the company that is providing them with those, with the salvage operations, or with with the machinery that needs to be replaced, the parts of the machines that needs to be replaced. So these loans are for these purpose. The belly has actually got nothing to do with this. Or the beller is also, it has basically, it has got nothing to do with the beller and the belly. It is between the ship operators and the person who are extending them a loan facility. Okay, so the ship operator will, in certain cases, keep the ship as security with the person who's giving them the loan, or in certain cases, the ship operator will keep the cargo as, because sometimes what happens is, if the ship is completely destroyed from the salvage operation, it is the cargo that could perhaps be salvaged, okay, or it could be certain times also the machineries, or some furnitures, fixtures that are salvaged. So in those kind of situations, this cargo will be hypothecated to the person who is extending the loan amount. So your question, Kinjal, is whether the beller and the belly is involved. The beller and the belly is not involved, but unfortunately, the cargo belongs to the beller and the belly, and that's the reason how the beller and the belly will come into picture. And obviously, there is all those indemnities are passed from one to the other. That if there's any loss occurred, we will make the loss good and all that. So everybody, all the parties will have their own rights to claim the cargo, or if the cargo is also completely destroyed, then to claim the amount of that cargo. And there are various other methods. Yes, bottomry bonds, respondentia bonds. These are all sort of insurances that have been given to, in case of any loss that occurs. Indemnity in case of any loss that has occurred. Okay, indemnity is a contract of insurance only. If you actually look at it from a very local language, if you forget the legal language and look at it from the local language, these are all sort of indemnities that have been given. These are all sort of insurances that are given. And yes, there are ways, means and ways of making these indemnities come into picture, and then making those losses good. And if somebody is sued in these cases, then the court will also listen to the matter, and whoever has the right to claim for any sort of damages, any sort of money, that all will go. But directly in bottomry and respondentia contracts, directly the beller and the belly is not involved. There is something else also, but why they come into existence and how they act and all. How is it different from insurance? It's a form of insurance, Kinjal, but how they come into existence and how they act and all this, that's something that I just spoke about. Yeah. Nirban Chakravarti has said bottomry and respondentia are marine insurance terms. Yes. My question to you, Anirban, is how extensively are they used in current scenario, in the current era? Question in a sense, I'm not telling that you should answer it immediately. If you have an idea, you can answer immediately. If you do not have an idea, maybe you can go back, check with your people in this marine context and speak about it. Okay, so I think I have tried talking about bottomry and respondentia. If they are not really relevant in today's context, we do not really need to spend so much of time on them. But yes, marine insurance is something that is extremely important issue and subject. I'm sure you would be having it as a separate subject in your syllabus. I don't know, I'm not sure whether you have insurance as a separate subject, or it is a part of some of your other subjects, because that's a very important thing. Because marine property And when I say marine property, I'm not speaking about the environment. I'm speaking about vessels, the cargo, even the people who are not speaking about vessels and cargo. I am speaking about, sorry, I got distracted. Sorry. I'm not speaking about the environment. I'm speaking about the cargo and the ship and all those things. They are at risk all the time. And therefore, insurance plays a very, very critical role. Also, when cargo, when shippers are sending cargo, they are insuring their goods and sending their cargo. And there's a lot of insistence on insurance, and there are clubs that are formed, which you all would also be knowing about. So these clubs are associations of people who are helping in getting the insurance to different parties. So, can I request you to please mute your? Yeah, thank you. So, yes, bottomly transactions are mostly obsolete in modern day maritime activities because yes, there are a lot of other means and ways that have come. Um, there's another thing about general average, which you all would have learned in some other subject. If not, we are also going to. You will also be learning about general average in the second year in law also, where you're going to learn the law of sea transport. So these are some of the things that you need to understand from bailment and pledge. Let us now quickly move on to our next topic. If there is any questions, anything that anybody needs to ask, can please connect with me post class on this, and then we can take it forward over there uh, on a WhatsApp discussion. Okay. So let me move ahead. And yes, when we were speaking about the Bailment Act, we were speaking a lot about the sale of goods. And I was saying, it's not a bailment transaction. That would be a sale of goods transaction. This would be a sale of goods transaction and all of that. So now let us understand what sale of goods is. And, again, uh, essentials of, a contract of sale. What is an agreement to sale? We will be speaking about all of that in this. Just give me one moment, people. Sorry. Okay. Uh, so yes, when we are speaking about so a lot of people had asked this question when we were talking about bailment, whether belly is whether the consignee is the belly. And at that point of time, I had said that no, the consignee is not the belly. In fact, the consignee is a beller, because the consignee is the representative of the beller. The consignee is the one who is going to take the goods um, the goods are going to be returned back to the consignee in that entire transaction of bailment. So the consignee is not the belly. The consignee will stand in the shoes of the beller once the goods have been transferred or transported by the beller. And then I said that I also said that the transaction between the shipper and the consignee, or the consigner and the consignee, to be precise, is not that of a beller and a belly. Okay, it is of a most often it is of the buyer and the seller. So why? is the shipper sending the goods and why is the consignee collecting the goods? In most cases, the shipper is selling the goods, or it is, is sending the goods, transferring the goods to the consignee because the consignee has bought the goods from the shipper and the shipper has sold the goods to the consignee. In most cases. I hope you agree with this. Okay. And for that, we need to understand what is this entire thing about sale of goods, or whatever that we want to speak about now. Okay, so when we speak about sale of goods, it has got nothing to do directly with shipping. Nothing to do directly with shipping. Of course, yes. In shipping also, within the shipping so when we are speaking about the sale of goods, when we're going to speak about the Sale of Goods Act, it has got nothing to do directly with shipping. But yes, in the shipping industry also, there's a lot of buying and selling that happens. Correct? There's a lot of buying and selling that would happen. Somebody's buying the vessel from someone. Someone is selling the vessel to someone. Someone is buying plant and machinery from someone. Someone is selling the plant and machinery to someone. Someone is buying your regular supplies on the vessel from someone. Someone is selling those vessels to someone else. So all that is there because selling is a commercial activity and it is not restricted to a particular industry. Like we spoke about the shippers and the consignee and all of that, uh, which may be restricted, and the port authorities and all that, which may be restricted to the shipping business, and somewhere also restricted to any kind of a transport business, whether it is your air business and all that. Sale of goods is something which is across businesses, which is across industries, okay? And not just industries and businesses. Sale of goods is something that you and me do every day. Every single day we are selling, more than selling, we are buying something. We may not be selling something because we may not be into the business, but every single day we are buying something. Okay, so we are constantly in the shoes of the buyer. And when we are constantly in the shoes of the buyer, let us understand what this entire thing of Sale of Goods Act 1930 is. Now, when we are going to speak about the Sale of Goods Act, one thing that I want to make very clear here is that the Sale of Goods Act only considers movable property. Now, what is movable property? Movable property is the property that can be moved. If you all can see this mug of mine, it can be moved from here to here. Okay. Book, move from here to here. Chairs, tables, fans, whatever I can see in my room, I'm just talking about that. Something that can be moved from here to there. I have all my grocery, which can be moved from here to there. Okay. There are all these things, which is your car, your vessel. All these are some things that can be moved. They are not fastened to the earth. Okay. So these are the things that can move, and they are all your movable property. Okay. Your immovable property basically is land and the building. Your crop also can be fastened. Okay, your fruits can be fastened. Once they are removed from the tree, they become a movable property. So everything that can move, that can be taken from one place to another, is your movable property. So your immovable property is only your land and the building, or the structure that is built on the land, that is your immovable property. And that is not covered by the Sale of Goods Act. There is a Transfer of Property Act which takes care of your immovable property. Okay, so here when we are speaking about the Sale of Goods Act, be very sure that Sale of Goods Act is only for goods which is a movable property. So let us understand what is goods. I've already tried to tell you a little bit about what are goods, but let us understand what it includes. Okay, this definition is only about things what it includes. So it may not be a very exhaustive definition, but yes, when it says every kind of movable property, it is about everything that can move. Not human being, but apart from your human being, everything that can move is a movable property. So every kind of property other than actionable claim and money. What is an actionable claim? An actionable claim is a suit that you can make in the court that cannot be sold. Okay, and money is your cash. Okay, it cannot be sold. You cannot sell money for money. You cannot sell your case in the matter for money. Okay, but what it includes stocks and shares. Okay, shares of company can be sold. Don't we sell them? Don't we make profit on them? Sometimes we also make a loss on them. Correct? So that is something, stocks and shares. Growing crops, grass and things attached to or forming part of the land, which are agreed to be severed before sale or under the contract of sale. So it includes every movable property other than actionable claim and money, but it includes stocks and shares, and it includes growing crops, grass, and things. Now, growing crop attached to the earth, crops attached to the earth, but growing crop or grass can be removed, it can be cut and it can be removed, it can be severed from the earth. Okay, so when it is severed from the earth, it could be sold. We see people selling grass, right? We see people selling crops, right? So when people are selling grass, when people are selling crops, how are they selling it? They are selling it typically after removing it from the earth, after removing it from the plant. You get your rice, you get your wheat, you get your barley, you get your apples, you get your, what is all that? These are all things which were fastened to the earth. They were on the tree, they were on the fields and all of that. And now, once they're removed from there, then they become a movable property. So goods are every kind of movable property other than actionable claim and money, and includes stocks and shares, growing crops, grass, and other things fastened to or forming part of the land which are agreed to be severed before sale or under the contract of sale. Goods are classified into different types. That is, the two very important types are existing goods and future goods. Now, what are existing goods? Goods that are physically there, that are present, are existing goods. And what are future goods? Goods that will be manufactured in future. Okay, goods that will perhaps grow on the crops, on the trees, on the field in the future. Those are future goods. And contingent goods are goods that are there ready, but they may not be for the purpose of sale immediately. Okay, those are contingent goods. Now, in existing goods, there are specific goods, ascertain goods, and unascertain goods. Okay. So specific goods are goods like this cup, this diary, specific goods. Okay. Assorted goods could be you want to buy 1 dozen apples, 1 kilo apples. Apples are sold on kgs, correct? And not on dozens. You want to buy 1 kilo apples, and they're there in front of you. You choose 1, 2, 3, 4. You put it in that weighing scale, and that person weighs them, and you get those apples. You have ascertained that these are the 3 or 4 apples in 1 kg that you have got. Can you do that with oil? Can you remove, that I want this oil, or even your crop, like your grocery, like your atta, or your chawal or your dal and all that. Chawal, perhaps you can start looking at 1, 1, 1, 1. But if you want to buy 1 kg of chawal, and if you're going to say I want this grain, this grain, this grain, it will be humanly impossible to do those things. Okay. So what typically happens is there is oil that is there, or there is milk that is there in a huge can. Somebody will just put a jar. You want 1 liter of milk, or 1 oil of milk, 1 liter of oil. They will weigh it as 1 liter, and they will give it. Those are unascertain goods that cannot be really separated from the rest of the goods in terms of I want this or I want that. It is general. So that is the classification of goods that we're going to speak about, that we need to understand. Now, contract of sale. Oh my God. Time. It's around 10 to 1. Okay, ठीक. We have about 10 minutes. Contract of sale. Contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property of goods to the buyer for a price. We saw in bailment what happens is there is no transfer of ownership. Correct? There is just transfer of possession of goods. But in contract of sale, what happens? In a contract of sale, there's a contract where the seller agrees to transfer the property of goods. What do you understand by the word transferring the property of goods? Transferring the property is equal to transferring the ownership. Please write it down in bold somewhere and keep. Transferring the property, the word means transferring the ownership. Transfer of property is not equal to transfer of mere possession, but it is equal to transfer of property, or transfer of ownership. Okay, so when we speak about transfer of contract of sale, it is about transfer of ownership of goods to the buyer for a price. I am giving this mug to my neighbor to use because there are some guests coming, and this is it's a very unique mug, and she would like to serve her guests, and I have 5 other in the same types, and serve her guests these mugs. So she's taking these mugs from me, and after the purpose is over, after she served her neighbors or guest, my neighbor is going to return back these mugs to me. That is bailment. The mug had gone to her, only the possession of the mug had gone to her for some purpose. Once that purpose is accomplished, I can go and stand in her door and say, please return back my mugs. I want them. Okay. But I am into a business of selling these mugs. And my neighbor comes and says that I want to buy 6 of these. I tell her a price. She gives me the money. and I have given her these mugs. Now, can I go back and tell her, please return back the mugs? I need them. No, I can't. Because I have sold the mugs to her. I have transferred the property in these mugs to her. Now she can go and sell it to anybody she wants. She can give it to anybody she wants. Whereas in bailment, see, I'm going to keep speaking about, and you must have observed that we keep going back to other forms of special contract also when we are doing this entire thing. Okay? And we'll be doing that. And why I'm making this as a point is we are completing our fourth lecture, correct? I am not really very good at math, but to my understanding, we are completing 60% of our portion today, or more than that, 70% of our portion today. I don't know, 60%. I will like to believe that 60% of the portion, because we only have 2 lectures left now in which we have to finish the remaining 40%. Okay. So little by little, we'll also need to speak about examination, because ultimately, why are we there in class? Why are we trying to understand all of this? Mainly to write our examination. Okay? And some of them are just for attendance, but otherwise, most of us are here to write, your examination. So why I am trying to go back to all these forms of contract is because in your examination, also in your answers, I will expect you to go back to all these things and try to uh, try to use all forms of special contracts and how they are applicable to a particular answer that you're going to write. I would be happy to see you doing that. Otherwise, let me tell you very, very clearly. Otherwise, it is just about giving you marks on your handwriting. Believe me, that is what is happening currently. Giving you marks on your handwriting, giving you marks on the presentation. Because out of 70, 69 answers are identical word to word. You all know how it is happening, why it is happening. But it is happening, not just in your course, it is happening across. We are sitting in our houses and we are writing our examinations. It is not very difficult for us to feel tempted to peep into the books and write our answers. And that is what is typically happening. And so then if that is happening, who do I score what? Do I give everybody 100 marks? I'm not going to do that. I'm not that kind of faculty. And I have seen all my co-faculties also not doing it. But then in order to be fair, what happens is then we look at, how has one presented their answer? What is the kind of handwriting that one has, written the answer in? And all of this. But if we see that, people have used some logic, people have not just, tried to use words verbatim from the textbook or the notebook that they are referring to. They're making use of good examples. They're making use of, connecting the concepts and all that. That will become a challenge for us also to correct the papers. And that will somewhere justify our corrections also. So that's the reason why I'm going to keep going back to all these kind of contracts that we have spoken about. So when we are speaking about contract of sale, again, it's a contract, correct? So if it's a contract, it needs to have all the characteristics of a special contract. And what are the characteristics of a special contract? The proposal, acceptance, consideration, lawful object, free consent, capacity to contract, legal formalities. Okay. Now, because we keep having this debate on, written contract, oral contract, or at least, there is apprehension in the minds of people. For that, I will again specify over here. So when we speak about transfer of immovable property, for a transfer of immovable property, a written contract is a must. And that contract doesn't just need to be in writing and signed by the parties, but it also needs to be also needs to be registered with the registrar of companies. I'm sure you all have heard about that, right? But in case of movable property, you do not need to have a return contract. You go to your baniya, your grocery man, to buy your grocery. Is there a return contract between you and the grocery man? There is no return contract, right? You just tell him, order that, I want 5 kilos of atta and 10 kilos of chawal and or rice and all of that, and kindly deliver that to my house. And he says that, okay, I will deliver it to you by so and so time. You pay him the money either there in the shop, or you pay him the money when the things are delivered. Correct? What is that? That is a contract of sale. Contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property of goods to the buyer for price. These mugs given to my neighbor for the money, that is, it becomes, and we are agreeing that now it is going to be her property. It is no longer coming back to me. That is a contract of sale between me and my neighbor for this stuff. Now, what happens in a contract of sale? There is a possession of goods given, and there's a property in goods also that is transferred. These are two different things. Okay, there is a possession of goods that is given, and in bailment, there is always the possession of goods that is given to the belly. Okay, even if the possession is not given physically, there's a possibility that my plants are lying in my house. I have given the keys to my house to the neighbor and gone to my native place. All my neighbor has to do is open my house with keys and come and water those plants and close the house and go back. Okay, the physical possession is not given, but the plants are in my neighbor's possession. But the ownership is not transferred. What happens in the contract of sale? Sometimes you have sold the goods. Okay, the goods are sold. Your baniya, you have given money to the baniya for that 5 kgs of rice, 10 kgs of atta, and all of that. But the goods are still lying with the baniya. The delivery is not taken. You would have told the baniya that, Bhaiya, we are going out for 2 days and all. Let it remain over there because your stock was going to get over. I am giving you this cash and money and all that. Let the goods be with you. When I come back, I will take the delivery of the goods. But you have given your grocery man the money, which means that the property of that goods is already transferred to you. You are the owner of those goods. Okay? So even if the possession of the goods is not transferred in you, what is transferred in you is the property of the goods. And that is the contract of sale. The contract of sale is when the property is transferred. Sometimes there's a possibility also that the property, there's a contract of sale but that will not be a contract for sale. We're going to see that. Let me not come to that portion just now. We will see that portion when we are speaking about a sale and an agreement to sell. Okay, a sale and an agreement to sell are again two different concepts. We will have to dwell on them more in detail. So we will be dwelling on them more in detail in the next class. It's 1 o'clock. I would like to wind up the class today because I have something personal immediately after this. So next class, we will be speaking about sale and agreement to sell. Of course, we will be speaking about unpaid seller. Yes, very importantly, we will also be speaking about conditions and warranties. We will be speaking about right of unpaid seller, and then we'll set
what we will cover in the next class.
Then we will set on. Can I request everybody to please go on mute? Then we will set on our journey of the shipping laws, where we will start with The first with introduction to Indian Coxa, which is a very small portion of the Act. We will be doing the Coxa in detail in the next year or something. And we will try to finish the Major Ports Act and the the Indian Ports Act and the Major Ports Act. Believe me, from the next class onwards, there will be no time for discussions. Sorry, because we are going pretty much slow because of all these discussions that we are having, and sometimes it's repeated over and over again. I would not mind taking your questions offline personally. How many ever questions you have, please post them on on my WhatsApp. You'll have my number. We will be going in that mode in the next 2 classes, because we only have 2 classes in which we have to finish 40% of our portion. So request all of you all to see to it that we are doing the rest of the classes very, very quickly. On that note, I would like to wind up today. Any questions, most welcome on WhatsApp. Most welcome.
We don't have your WhatsApp number.
Who's this? Who's this? Is this your first class? So then please take it from the rest of the class, because this is my 4th class, I can't go over and over again and again with the same things.
Sorry, madam.
Yes, thank you for answering that. How do I pronounce the name? Roxanne? Sorry if I've pronounced it wrongly, but thank you for answering that question on what is an actionable claim. Okay? Yes. Thank you, Anurag, for that huge description on maritime salvage and all of that also. Yes. Okay, if there is anything, please connect with me on my WhatsApp. Okay. Thank you. No calls. Only if there is a dire necessity, I will request you to call, because I am throughout the day either in meetings or in other lectures or in some seminars or something like that. So I will not really have time to attend to everybody's individual calls. If there is anything, you can please write to me a message. And if I feel there's a necessity for us to talk, I'll ask you to call me back. Thank you so much, everyone. Bye-bye.